Hello and welcome to our video. My name is John Watts. I'm a consumer protection attorney in the state of Alabama. We're going to talk about a company that is filing more and more lawsuits against Alabama consumers, and every single one that I've seen has violated the Fair Debt Collection Practices Act. And the lawsuit itself is just a bogus lawsuit. And I'm talking about the company called Velocity Investments. Now, this is a company, I'm not even sure where they're from, but they have come into Alabama and they claim to have bought up old car loans, vehicle loans. Typically after repossession, there's something called a deficiency. And so they're suing for that. And they typically use a very experienced law firm. They've been in the collection business a long time out of Mobile, and that's Barry Friedman's firm. So if you get a letter from Barry Friedman, take that very seriously, because that's what he does. He sues people, and he knows what he's doing when he sues people. This is not an amateur or a newcomer to this world of filing collection lawsuits. He's been doing this a long, long time. So what's the deal with this company, and why do I say that they are breaking the law? Well, they claim to buy this old debt, but we have never seen them actually prove that they own it. And here's what I mean. So here's the typical scenario. You go to the car dealer, and the car dealer says they're going to finance this car for you. Okay? You're buying a car. That's the sale of a good under the law. But then they're going to, maybe the same day, within a week, boom, they transfer or sell that loan to somebody else. So you start off with car dealer, and then it gets sold to, say, Citi or Cap One Auto or some other company. And then that company will have it a while. And then they sell it to Santander, who's sort of a famous or an infamous car loan place. And then Santander, usually at that point, there's a repossession, and they'll say, all right, you owe 20 grand, we got 8,000 in the repossession, so you owe us the difference, the deficiency of $12,000. So 20 minus 8, going to be $12,000. And then Santander will try and collect it for a while, and then they'll sell it to a company called Cascade. And then Cascade will sell it to a company called Velocity. Now, when I say sell it, I mean they supposedly sell it, because you weren't there. You don't know this. So Velocity has got to prove they really bought it from Cascade, and then they have to prove Cascade really bought it from Santander, and then Santander really bought it from Citi or Cap One Auto, and then those companies really bought it from the dealership. Now, they hate having to prove that. And a lot of times they come into court, these debt buyers do, and they say, Judge, that's so unfair that we have to prove this. That would take a lot of effort to prove it. It's funny when we've handled huge cases, wrongful death cases, class action cases. I've never been tempted to come into court and go, Judge, this is going to be really hard to prove, so you should just make the rules go away so I don't have to go to any effort. No. Velocity, if you're going to buy this stuff and you're like number 5 or 6 in line, then you need to be willing to prove you own it. But even if they can prove they own it, here's the problem with Velocity. In my opinion, I feel very strongly about this. I think the law is absolutely clear. 4-year statute of limitation. So when you stop making the payments, and then they say, all the loan is due right now, or they repossess, then that's when the clock's going to start ticking. So at least at the repossession, usually months before the repossession. And then there's 4 years to sue you. Well, Velocity will sue you at year 5 or 5.5, close to 6 years. And that's just not statute of limitation. Well, what's the problem for them? The problem for them, the advantage to you, is if they sue after statute of limitation, they're supposed to lose that lawsuit. So even if they bought the debt, which I've never seen them do that, but even if they could prove they bought the debt, they wait too long to sue you, they lose. Here's the other problem. They know what they're doing. Velocity is in this business. They're a national company. They know what they're doing. They've hired very experienced, very skilled collection counsel. They know what they're doing. They're filing these lawsuits after statute of limitation. Under the FDCPA, Fair Debt Collection Practices Act, it's a violation of the law. And you can sue them in federal court for doing that. So if you get one of these lawsuits, take it very, very seriously. If you get a letter from Barry Friedman's office or any collection lawyer, and you go, wait a minute, that's beyond that 4-year statute of limitations, write them a letter. Say, hey, I dispute this. I think statute of limitations has expired. Why are you threatening to sue me? Okay? See what they say. A lot of times they just won't respond at all to it. And then sometimes they just sue you even after getting that letter, which doesn't make any sense. But whatever the situation is, understand you have rights here. And you have 5 options when you're sued by Velocity. You could bankrupt against it. I've never recommended to anybody sued by Velocity they bankrupt. But technically it's an option. You could fight it on your own. Sometimes that works. Now understand, usually you're sued in the higher court called circuit court. There's discovery, some kind of complex rules. So if you do it on your own, make sure that you're very, very prepared and you're able to argue Alabama law and understand Alabama rules of procedure. Third option is you could settle it on your own. But if they sued you after 4 years, I'm not sure why you would do that. So bankruptcy, fight on your own, settle it on your own, hire us to fight it, hire us to settle it. Now, my opinion with Velocity, and we'll see this also with a company called Cascade Capital, is I'm not sure why you'd want to settle with these companies. When they're suing you after the statute of limitation, you should be able to win that case and then sue them in federal court. So hope that this is helpful to you. If you've been sued by Velocity, you're getting a letter from Velocity, from somebody else on behalf of Velocity, from a collection lawyer for Velocity, whatever it is, give us a call. 205-879-2447. That's 205-879-2447. We represent people all over the state of Alabama and be happy to represent you wherever you are if it's appropriate for us to represent you. The way we figure that out is we have a conversation. There's no charge for it. We'll go over your options. Should you settle it? Should you fight it? We'll help you think through all that. You can also get in touch with us through our website, alabamaconsumer.com. There's a contact us button or form in there, and then you can get in touch with us. So however we can help you, we'll be happy to help you and look forward to chatting with you, and appreciate you watching this video, and we'll see you in tomorrow's video. Okay, bye-bye.